In terms of this word, trust, what are some of the do's and don'ts of trying to establish a trustworthy, reputation, one that you have, but how do you establish trust in the process?
Very important not to misrepresent or overstate things. Very important that when you say a thing, it's correct, and the party on the other side can have some comfort that it is correct. Again, in my practice, I will deal with the same lawyers over and over and over again, and that's been the case for the decades I've been practicing in this area. You learn very early these are relationships that will matter. They mustn't be spoiled. The lawyer on the other side needs to know when dealing with me that I'm determined, that I'll see this through, that I want a result, but that I can be trusted to be honest. If I'm asked something and I answer, it'll be correct.
What are some of the things you don't like about the other side in terms of trustworthy behavior and activities?
Sometimes what you see is a lot of outrage and language on the other side that you know is not grounded in reality. The individual's not done his or her homework, isn't well informed, perhaps hasn't spoken to key witnesses, really isn't coming from a knowledgeable place. And that can be a real challenge. Every once in a while I will run into a lawyer, and it tends to be some of the same people that I know isn't really interested in problem solving and just wants to litigate the matter. And that's frustrating. My bent tends to be for my clients to want to solve a problem and not to litigate it unless it's absolutely essential. But there are some lawyers where that just isn't how they operate. And maybe they've been selected by their clients because that's how they operate.
But most of the disputes end up not going to litigation.
That's right. Most disputes are solved. Most probably 80% of the matters that come into my office are solved without a claim ever being started. And even with those where the claim is started, 99% of those will settle before trial, typically quite early in the process.
What from the other side don't you like in terms of trust? You mentioned the braggadocio.
Yes, bluffing, not well prepared. Some of the things that I find difficult to deal with are things like, Janice, you need to know this about your client. Now, don't tell him. Don't tell him I've told you this. We don't want to upset him. But you need to know, this is what we're dealing with on the other side. Well, what am I supposed to do with that? How can that be helpful? So generally what I have to do when something like that develops is, please don't talk to me about things I can't share with my client. That's not going to advance us. It will be frustrating if the other side changes its position, starts to go backwards on its position, having initially said this is what we're prepared to do, but you didn't take it, maybe you countered, so our original position isn't available anymore. There's frustration in that, mostly because you just know that it probably isn't real, and if you just pushed back, you could get it
Have you
done.
ever encountered the situation where you've done all your preparation, you've entered the negotiations, you've exchanged letters and back and forth, et cetera, and you're just about to close, and then an issue that you have forgotten about or your client didn't really share it with you comes to the forefront? I think of the nibbler,
Yeah.
Some of those negotiators who get 3 or 4 things and they say, well, we've got one more thing that we want to get done.
Need.
Have you had those experiences?
Yes, and if I'm candid about it, I'm more often in that position of saying, oh, wait a minute, there's another thing I need. And I know that can be frustrating to the other side. It can be a function of my client, as you say, just having thought of something he or she had forgotten to tell me about, or that suddenly occurs to the individual. A negotiation is a live process, and until it's done, it isn't done. You need to be patient.
Well, let's talk about patience. What do you mean by patient?
It's a process. So often, especially when we're new to this, we think, well, this isn't difficult. There's nothing terribly complicated about this case. We should be able to get it resolved with a conversation. What could possibly be difficult? It is a process. Some of the simplest cases the parties need to follow the process. They need to see the give and take of a negotiation before they will be comfortable with the result. Sometimes they need a chance to know that they've been heard. It doesn't need to be in front of a judge. It's enough if it's in your letter. It's enough if they have a chance to speak, perhaps at a multi-party meeting or with a mediator. So there is a process about a negotiation that often has to be respected, and that requires some patience.
Have you found in your experience that clients have to empty the tank?
Oh, yes. Yes, plaintiffs in particular, and most of my practice is for individuals making claims. They need to know they've been heard. My clients often are feeling hurt, offended by what's happened, wronged by what's happened, and so often just need a chance to express it. Then it will be possible to park it and be businesslike about, yes, but what do I really need now to go forward?
You've found that has happened more than once or twice?
Very common.
Very common.
Yeah, and defense counsel generally know that and allow it to happen. Defense counsel often, they recognize it's not worth getting upset about this, let the individual vent, and then we'll be able to have a better conversation.
You've had a lot of high-profile cases. Do you use the media? Does the media use you? How do you handle that?
You cannot manage the media. I do not, just about never try to use the media. I can think of less than a handful of occasions where I have felt that the media might be helpful. Sometimes I've had a client who is high profile, perhaps even with a journalistic background of some kind, who really can use the media and knows what he or she is doing. As long as I'm talked to in that process and things don't get wildly out of hand, I cope. But it is rare that the media is helpful to advance a particular case. The media wants a story.
Yeah, they want the fight.
They want the fight.
So what's
now,
your practice? Not to talk to them or talk to them on background?
I will always talk to them if they want to know about other cases going on, developments in the law, that sort of thing. I'm always delighted to do that and tend to be very responsive to that. That's good for everybody. When they want to talk to me about my client, I work that out with the client. Sometimes it's important to say something. Sometimes it's better not to fan the flames by saying anything at all, and the story goes away. It varies. But if there's one thing I have learned, it's that you can't manage them, and you need to be careful.
We have such a proliferation of different types of media.
That's
now.
right.
We've got the established media, we've got print, we've got
Blogs.
the blogs, you've got people who are texting left, right, and center, and it's sort of a...
More than ever, you can't manage it, really.
You go down that road, you're looking for danger.
That's
in
right.
terms of your negotiation and getting a settlement of some sort.
Parties often need a quiet settlement. It's rare that it benefits them to have the thing talked about in the media. So generally, I avoid it. But interestingly, I've often had to have that conversation with my client. Oh, I'm going to go to the media on this if they don't smarten up and play ball. I will say, well, you know, that probably isn't going to be all that helpful.
Yeah, there's always a huge risk.
Huge risk.
What about cases where you don't really have a time frame that seem to be on running for long periods of time, residential schools, et cetera, et cetera?
Nortel.
How do you plan for those kinds of things? Because clients are always, I would say, for instance, on the Nortel, they're very interested in having the matter resolved.
Oh, yes. That's just at the far end of the spectrum in terms of a case that goes on and on and on with the clients, with the claimants, I'm sure, feeling like they will simply never see their money, and it's a very unsatisfactory state of affairs.
Has that matter been resolved?
No. That matter remains unresolved. The big debate is how much money will stay in what country, and what pools will be available to satisfy creditors. That matter is coming to trial. It's enormously complex and a very expensive matter to resolve. So it's a frustration. The more normal situation is you have a party on the other side that really isn't motivated to get it done, and your own client who needs to get the thing done to get on with his or her life, and that's frustrating. The smartest thing you can do for that kind of case is to figure out how to advance, if it's a piece of litigation, quickly. We've been handed a decision from the Supreme Court of Canada recently saying, look, lawyers should be using motions for summary judgment on these files. Files should rarely go to trial, the Supreme Court of Canada has told us. Find ways to bring them before us so that we can make early, quick determinations without the delay, without the expense. The court has signaled just last month that this is what it expects us to do, and I think that's a good example of how to deal with those cases that just won't go away.
Now, how do you deal with those individuals on the other side who are deceptive, obnoxious? How do you handle that?
In writing.
In writing?
In writing.
Tell us about that.
Sometimes you just know that a conversation, I'm thinking of a negotiation I had recently, nice guy, always wants to talk to me on the phone, but we don't get anywhere when we talk on the phone. So towards the end of that negotiation, I started to say, no point, you've got our position. Or this is all I'm going to be able to do. There's no point in talking. And that worked. That brought in the settlement. So sometimes it's in writing. You remember that if you make an offer to a lawyer that's difficult to deal with, he has a duty to take it to his client. So you know that offer is going to be presented to the client and may speak to the client in a way that you're not getting through to the lawyer. The other technique I will sometimes do if counsel is a problem on the other side is suggest to my client, or the client will suggest it to me, can I speak directly to the client on the other side? Maybe if I go for coffee with so-and-so, we can get this done.
Does that happen?
Yeah.
And what has occurred?
What I will do is, if the client is up to it, I will say, sure, the clients can talk, but just be careful. Don't give away the store. I will coach the client in terms of how to handle the discussion.
Would you be present?
No, I couldn't be if the other lawyer isn't present. I cannot speak to the client on the other side. My client can. There's nothing wrong with that, but I can't be present. So I will coach my client. I wouldn't suggest that unless I felt it was a sophisticated individual who would be able to have a better discussion than the discussion I'm having at the moment with the lawyer. It will often break up the logjam.
From your perspective, what are some of the biggest stumbling blocks in terms of resolving disputes? Would it be ego?
Ego. Sometimes it's just as simple as dealing with an entity that knows it's going to have to pay in order to get this matter settled, but frankly would rather not pay right now, would rather pay the lawyer to keep the problem at bay and deal with it later. Deal with it when it has to deal with it, which comes back to the whole notion of not waiting for trial and bringing it on before a judge as soon as you can. And that can be a very effective way, again, to force the issue. Sometimes you're dealing with a party that's simply distracted by a lot of other things, and your problem is just not present to mind. The mediation process can help solve that.
Are you finding that lawyers are now using more mediation than they have in the past
Much
to try to
more.
resolve the disputes?
Much more, and it's enormously effective. particularly, frankly, in employment matters, but in all sorts of legal disputes. It's enormously effective. Not every time, and sometimes you have a good try on a day and then you pick it up months down the line when more time has gone by, perhaps discoveries have happened, the parties know more and they're ready to have a better conversation. But it's almost always a useful exercise, even if it doesn't get you to a deal on the day.
It clarifies the issues?
Clarifies the issues.
The real issues.
The real issues. And the parties will come back the next time they're talking to each other and say, now, where were we when we were mediating? What notes did I make? What was I thinking? What was the other side thinking? And it will often be the basis then for the next round of discussion.
Now, you've been involved in hundreds upon hundreds of different negotiations.
Mm-hmm.
What are some of the qualities and who are some of the best negotiators that you've seen and maybe have tried to emulate over the years?
The well-prepared person, the person who knows the file, knows the facts, has taken the trouble to speak to key witnesses, and is just well prepared to deal with the demands I'm making. And frankly, the individual, I said a moment ago that it's frustrating when I have someone on the other side saying, now, I don't want you to tell your client, but you need to understand A, B, and C. Maybe I get annoyed at that because it's effective. That conversation can be effective. It's sort of, Janice, you need to understand, we know what you're saying, but we have a different perspective here, and there's a reason for it. And so it's not resonating with us. And you need to find a way to help your client understand that the kinds of things you're saying just aren't going to work. Or this is where we're headed if this thing can't get resolved. Have to be so careful with that stuff, though, because you don't know whether you can believe everything you're being told. I'm thinking of a negotiation I'm having right now where I'm being told your client has done this, this, and this, and we've got documents. We've got email. There's email on everything now. What I will do with that is say, I can do nothing with this unless you give me the documents. I've got to see them. I can't just take your word for it. And generally, you'll get the documents, and often they won't say quite what you've been led to believe. Close, maybe, or maybe they will.
In addition to being well prepared as a negotiator, where does confidence come into play?
Confidence is so important in everything we do. It's 50% of the battle. And you show that confidence by listening well, speaking knowledgeably, sensibly, and just letting the other side know, this matters, I respect what you're telling me, but you need to know this matters a great deal to my client, and we are going the distance, and you know I will if I need to, and you know I will do that. So, self-confidence in any negotiation is critical, but it's got to be an informed self-confidence. Probably nothing more dangerous than going in half-informed or not well prepared. When I've been unimpressed, even with a senior negotiator, it's been more often than not because that individual doesn't know his file, and it's just not working.
Who would you classify as a top negotiator?
As a top negotiator, I can think of lawyers in town that are effective. It's interesting, when I was thinking about that before coming today, the people that I often get to a result with more quickly are some of the same people I would say are excellent negotiators. And I think that must be because I know I can trust them. I know I'm not being sold a bill of goods. I know they have an understanding of the law. I know they have a wish to problem solve and not to litigate unnecessarily. One of the lawyers I'm thinking about in Ottawa, I remember having a pretrial with him in front of a judge a few years ago on a difficult case. And he said to the judge, Janice and I have never had a trial. We've had hundreds of files. We get them resolved. And he was proud of that. So the individual who is looking to solve problems for his clients, those are the individuals that I've found most effective. Sure, the individuals that put you off, won't talk, make your client wait. Are they effective in that they're not paying now? Maybe, but they will pay eventually, probably.
I had an experience. I had met with Shimon Peres, who's now the president of Israel.
Yeah.
And I talked to him about negotiations. And he said a couple of things. One of them is that you have to be extremely well prepared.
Yes.
And you can't fake being well prepared. Because he said, if I fake being prepared, the other side will know
That's right.
I'm faking.
That's right. I couldn't agree with that more. And I am recalling vividly, very senior counsel in Toronto that I have a lot of respect for, doing a matter with me years ago that he had obviously not taken seriously. He did not know his facts. We got the deal done. But he didn't play a role in the process.
I'm glad you're sharing with us the importance of preparation, because I find, for instance, in the business school here, there's a lot of young people who may go out, first-time jobs. Some of them are in the MBA program, and who read these things about preparation. But it doesn't register.
No.
It only registers until you're actually in the fire, in the battle for the negotiations. But the preparation is so important.
Yeah, it's utterly key. I remember being told that in law school and thinking, yeah, you know. But I remember that probably better than almost anything else I learned in law school. And there's nothing more frightening, frankly, than finding yourself in the throes of a process and not understanding it, not having what you need to understand it and be effective for your client. It's
Have you come across some bullies in the negotiating process?
Yes. Yes, over the years, less so as you get longer in the tooth. I don't get bullied as much as when I was a young lawyer, but yes, there are bullies, and you see, I see lawyers of my vintage doing that with my younger colleagues sometimes. And so my role in that is to just educate them in terms of how to deal with that. And you just don't participate in that process and return to writing letters.
It's a neat way out, isn't it?
It is. Janice, we can't do, and the haranguing that I have heard and still will occasionally hear, it's just not helpful to the process. So I'll bring that conversation to an end and go back to writing a letter.
Now, if you were advising young people who are finishing up their university education and trying to get into the workforce and to get on with their careers, whatever they may be, law, business, etc., what would your advice be? Because I think young people are having particularly great challenges.
It's harder. It's harder than when we came out of school, frankly, to land work. What I'm seeing young people, some of them do very well, is networking, speaking perhaps to their parents or their parents' colleagues. I had a client call me last week saying, Janice, would you mind very much talking to my son who is in first-year law and wants to understand better what's coming up and what he should be thinking about? And I said, sure. And was happy to spend 10 minutes on the phone with the individual, and I think it was helpful to him in terms of helping him get a picture. So the networking, talking to people, one of my own kids, I've seen her do that very effectively in terms of thinking about, well, is this what I really need to do, or is that?
So I have to be able to adapt.
Yes, yeah. The preparation, the research, there's so much information available to us now, so much more than used to be there. Being, excuse me, really well informed about who you're talking to. If you're into a job interview, if you're exploring opportunities with an organization, take the time to learn about that organization and be well informed when you arrive. ask questions of the people talking to you that you know they'll want to talk to you and enjoy answering you. That sort of thing, it can all be really effective.
Well, look, thank you very much on behalf of the Ted Rogers School of Management.
It's been a pleasure.
The professors and the students for sharing your time and, most importantly, your insights about the negotiation process. I mean, you have a fabulous reputation of being a first-class lawyer in employment-related matters, and we're just delighted that you could have time to be with us today. Thank you very
kind,
much.
but thank you very much.
Thank you.
It's been a pleasure.